Okay, welcome everybody. I want to do units 6 and 7 today. Might sound like quite a lot, but it's not actually that much. We should be able to finish it without too much effort. You might be finding the work a little bit, how shall I say, disconnected at the moment. Can you just give me another thumbs up? Can you see my screen? I've shared the page where I take the notes. Can you all see that? Okay. As I was saying, the work might seem a little bit disconnected at the moment. These last couple of units seem to consist primarily of just sort of different loose terms. So quite a bit of studying there also, but it gets better. So just hang in there. Once we've finished with the law of contracts, the general law of contracts, we move on to contracts of purchase and sale, which I think you will find more interesting and easier to follow. It's not just big words. Okay, so what we've done so far, we've looked at the requirements for a valid contract. Those 5 requirements have to be present for a contract to be valid. The contract is not, if one of those requirements is missing, then the contract is said to be void. Then on Monday, we looked at the contents of contracts, certain terms that are that you will come across on a regular basis. So tonight we are looking at breach of contract. Let's make that bigger. So we're going to start off looking at breach of contract tonight, and then following that up with termination of contracts, units 6 and 7. Now, very, very important for proper understanding of this work that we're doing today is that we are dealing with a contract that is valid. Once the contract is valid, it stays valid. It doesn't somehow suddenly disappear. That's a very important concept. We're talking about breach of contract. What is breach of contract? That is when one parties does not perform in terms of the contract. So somebody does something wrong that they're not supposed to do. Now, please, I'm reiterating myself. If there's a contract between Evelina and Haiku doesn't perform in the manner that he agreed to perform, it is very important that their contract remains valid. If Haiku has done something wrong, the contract doesn't randomly, poof, disappear, become void. It's important because later in this unit, we're going to be looking at remedies. What are remedies? Remedies is like a cough remedy, a medicine, something that the court will allow to the innocent party It's a legal means of protecting the, type this out, legal protecting parties' rights. Now, right at the beginning, let's scroll up. That's why I teach this way, because I can always go back and show you that I did do this, and you can't say, no, ma'am, we never did that. Law of contracts, we looked at valid, void, and voidable. If a contract is void, there are no rights and duties. There is nothing that you can claim. It is a nothingness. So your intelligent brain should tell you now that if one of the parties has acted incorrectly, if the law provides that, then suddenly that contract is void. The innocent party does not have any rights. He or she is not protected. It is essential for the protection of the innocent party's rights that the contract remains valid. I'm stressing this because these are mistakes that are commonly made. If I give you an assessment, I give you a question concerning breach of contract, and you'll tell me, Heiko did something wrong, now the contract is void. No, 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 absolutely not. If Heiko did something wrong and the contract were to suddenly be void, Evelina will not have any protection. She will lose out. Contract stays valid. In fact, just one of my distinction questions. I'm going to perhaps ask that either in the first test or in the exam. Answer to that is, it is absolutely false. The contract does not become void. It remains valid. Okay, having said that, there are different types of breach of contract, and you need to be able to distinguish between the different types, and you need to identify the type of breach of contract. So our first one, this is mora creditoris. This is Latin. Unfortunately, I try to avoid using Latin terminology. When I started off studying law many, many years ago, as in literally very many years ago, we still actually had to study Latin as a subject. Fortunately, that is no longer required, but our law comes from Roman Dutch common law, so there is still some terminology which is occasionally used. Ach, not mora creditoris, sorry, my bad. Mora debitoris. Before I start explaining mora debitoris, I have to take a step back and just make sure you understand something. In law, we also use the words debtor and creditor. Now, you're all accounting students, so you have undoubtedly come across the terminology debtor and creditor. And the way that you've been taught, you've studied this terminology in accounting is 100% correct for the purpose of accounting. In law, however, the meaning of the word debtor and creditor is not exactly the same as the meaning would be in accounting terms. Contracts consist of obligations, rights, and duties. For every right, there is a duty. For every duty, there is a right. You can never have a right without a duty. They always go hand in hand. But in a particular contract, there will be multiple rights and duties, not just one. And if we talk using the terms debtor and creditor, we're talking about the duty, about the particular obligation, not about money. The terms debtor and creditor have got nothing to do with money, or don't exclusively relate to money. The debtor is the contractual party that has the duty to do something. The creditor has the right to receive. I'm putting those capital letters in there on purpose. It's a way of remembering. The debtor has the duty to do. The creditor, the debtor, make that a capital letter as well. The creditor has the right to receive. Work with me. Daniel sells his cell phone to Evelina for $1,000. In this contract, there are two obligations. There is the obligation to pay. Evelina bought the cell phone. She has the obligation to pay. Is she the debtor or the creditor? Come work with me, or I'm not going to do it so slowly, and I'm just going to lecture without stopping for pauses. Yes, Louis?
Miss, I think she would be the debtor in that situation because she's the one that has to
Louis, your
do,
hand
so
is
she
up.
has
What
to
do you
pay.
want? You can speak.
Is my mic off? Oh, my mic.
Sorry, Louis, you can try again. Maybe I can hear you
Okay.
now.
Well, can you hear me, Miss?
I can hear you now. Sorry for that.
Okay. I think she would be the debtor because she's the one that has to do, she has to pay him for the
You
cell phone.
you are correct. You are correct. But now don't go offline. Don't switch your mic off. The obligation to pay, she is the debtor. But at the same time, there is another obligation, the obligation to deliver the phone. Evelina bought the cell phone from Daniel. She has the duty to pay him. Daniel has the duty to deliver the phone. With regard to the delivery of the phone. Is Evelina debtor or creditor?
She would be a creditor because she has to receive it.
Absolutely. Thank you so much. That is absolutely correct. It's not that difficult. You just need to remember you're not only talking about the money aspect. The money aspect, debtor and creditor, has the same meaning as accounting, but there are other obligations as well. And with regard to the obligation concerning the delivery of the phone, Daniel is the debtor. He has the duty to do, he must deliver, and Evelina is the creditor. She has the right to receive. Not that complicated. Just think a little bit more widely than you would in accounting terms. So mora debitoris obviously relates to the debtor. Mora can remind you of not today, but tomorrow. It comes tomorrow, actually comes from the same from the Latin root mora. Mora debitoris, the debtor performs late. So if the contract stipulates that payment must be done, or let's move away from payment. Contract stipulates that delivery must be done on Friday. And by Saturday, Daniel has not yet delivered. There is breach of contract. He has done something that he's not supposed to do. He hasn't acted in terms of the agreement. Type of breach will be mora debitoris. He did not perform, he did not do his duty in time. Now, when must performance take place? When must performance take place? When will we know whether he's late or not? Sometimes the contract will stipulate a specific time. That's easy. Or if there's no time specified, within a reasonable time. But now it gets a little bit interesting and maybe complicated. It's straightforward. If you've agreed performance must take place on Friday, Saturday arrives, performance hasn't taken place, there will be breach of contract, there will be mora debitoris. But if there's no time specified, it is important to remember that the debtor will not automatically be in breach. Creditor must first give notice. So what this means, what the implication of this is that if Evelina buys Daniel's cell phone, but they do not agree on a date for delivery, and 2 weeks later, he has not yet delivered the phone, there is still no breach of contract. Evelina needs to give him notice. Notice is often generally in writing, but it doesn't have to be. It can be orally as well. Evelina has to give him notice. Evelina has to say to him, Daniel, can I have the cell phone on the 15th of March? And only if the 15th of March has come and gone without delivery will there be breach. So if the time was stipulated, the moment the time has passed, there is automatically breach of contract. If no time was stipulated, there has to be notice has to be given. Now, this next one is often confusing. But it will only be confusing if you don't properly understand the concepts of debtor and creditor. Mora creditoris. Creditoris relating to the creditor. But now, if you're wide awake, which I'm sure you are, you should immediately start being confused and saying, but now how can this work? Because the debtor has the duty to do. If he doesn't do on time, he does late, mora debitoris. But the creditor only has the right to, is the one that has the right to receive. So now how does this work? Because the creditor doesn't have to do anything, so they can't do anything late. What exactly is mora creditoris? The creditor, so the one that has the right to receive the performance, does not make performance possible. So it's not being late, although it also uses the term mora, doesn't have anything to do with being late. The creditor does not make the performance possible. So Evelina has bought Daniel's cell phone, and they agreed that Daniel will deliver the cell phone on Friday. And Friday, he tries to deliver the cell phone, but Evelina is nowhere to be found. So he cannot do what he has set out to do. He tried his best. He's not doing anything wrong. He's not in breach of contract. Evelina will be in breach of contract because she did not make the performance possible. She was not there to accept delivery. Everybody with me? Yes, Evelina, your hand is up. Is that a question?
Yes, ma'am. I wanted to ask, what if the case is that the individual does not pay?
Okay, now you're saying if the individual does not pay at all or pays late, there's different types of breach. For our example that we use now, I specifically refer to the obligation to deliver the phone because I wanted to move away from the monetary meaning of debtor and creditor. But it would be exactly the same. If you bought the cell phone from Daniel, your obligation is to pay. And if you had to pay on Friday and Saturday has come and you have not paid, it will similarly be mora debitoris. But there are other, and we're going to look at some other types of breach of contract now, where if, for example, you have to pay $1,000 and on Friday and you only pay 500 on Friday, that will also be breach of contract, but it will in fact be a different type of contract, namely the next one on our list, defective performance. Defective performance, there is performance, but performance is done. Performance is made. Now my English isn't Englishing here. Performance is made, but not as agreed. So if you do pay on Friday, but you only pay 500 and not 1,000, that's still breach of contract, but it won't be classified as mora debitoris. It will be classified as defective performance. So a contract can be broken up into different obligations. We use purchase and sale just as an example. The obligations there are delivery of the thing sold and payment. And for each of that obligations, there's a debtor and a creditor. If the debtor performs late, it's mora debitoris. If the debtor tries to perform, you try to pay him, but he wasn't at home, it will be mora creditoris. Creditor didn't make performance possible. Same for the obligation to deliver. With regard to defective performance, you paid, but you didn't pay the amount. Or he delivered, but he delivered a broken phone. So it's still breach of contract. It's just classified differently. It will be defective performance, not performing as required in terms of the agreement. Is everybody with me? Any questions? Okay, Daniel is with us. Great. Okay, so we've done mora debitoris, creditoris, defective performance. The next one is repudiation. Repudiation contractual party does something the terminology that I use in the notes, you must always go back to the notes. Terminology that I use in the notes is a little bit more formal. I'm making it more informal here to get the message across. Contractual party does something that makes it very clear that he or she does not intend to continue with a contract. So an example of this would be, let's say we're still busy with Evelina and Daniel and the cell phone. Evelina has for the cell phone on Friday. And on Thursday, Evelina finds out that Daniel has given the cell phone to Mitchell as a gift. His actions makes it very clear he has no intention of continuing with the contract, delivering it to Evelina, because he's given it to Mitchell. He can't deliver it anymore. That would be repudiation. Another example of repudiation, perhaps more common, is if I've offered somebody a job and they're supposed to start working on the 1st of the month, and a week before that, they start working somewhere else. Doing something, making it clear that they have no intention of continuing with the contract. that is known as repudiation. Similar factually to repudiation and prevention of is prevention of performance. Quite often, in a factual scenario, it is not quite possible, or it's sometimes confusing, sometimes difficult to distinguish between repudiation and prevention of performance. The same facts might give rise to either repudiation or prevention of performance. I normally accept the alternative answers there. So if the question is identify the type of breach of contract, and the facts indicate that it can either be repudiation or prevention of performance, I will give maximum marks for both. Prevention of performance is exactly what it says. The data does something that makes performance impossible. So gifting the phone to Mitchell can also be regarded as prevention of performance, because he did something that made his performance impossible. The two are factually quite close together. So that's when you sold a horse to somebody, and before you have to deliver the horse, you shoot the horse, you kill the horse. Those two are the lines between repudiation and prevention of performance are often quite blurred. Questions? No questions. Okay, now, if there's breach of contract, the law sets out to protect the innocent party by way of remedies. As we've seen, remedies, the legal means of protecting an innocent party's rights. Now, there are three possible contractual remedies that can be granted, namely specific performance, cancellation, and damages. What is important for you to understand? Okay, let me first explain what they mean. Specific performance is a court order that orders the breaching party to perform as agreed. So an order saying you agreed to do that. So if you have a contract with somebody for them to build a wall, and they've built the wall, but the wall is not the right height, whatever specific performance would be, go back and fix the wall. Go back and fix the wall. Or we had Evelina and Daniel, we had the example of Evelina only paid 500 instead of 1,000. Specific performance would be Evelina pay the rest of the money. So do what you are supposed to do. Cancellation, on the other hand, is an order that the contract is cancelled. Careful here. Cancelling the contract is not the same as the contract suddenly going void. It doesn't go void. It is cancelled. It comes to an end. Now, let's see how sharp you are. Contractual remedies. You can get specific performance or cancellation. But you can never get both. You can never get specific performance and mic's off, please. You can get cancellation or specific performance, but you can never ever get both at the same time. Why not? Come, think about it carefully. Mr. Manar, why can you not get specific performance and cancellation at the same time?
Well, I think because you can't be ordered to do something specific if you've been ordered to cancel the contract, meaning you don't have to do anything anymore.
Absolutely perfect logical insight there. That's not a very difficult legal issue. It's logical insight. The one says, do what you're supposed to do in terms of the contract. The other one is, there is no more contract. There's nothing you need to do. You can't do something if the contract, perform in terms of a contract if the contract has been cancelled, because cancellation means nobody needs to perform anymore. Cancellation and specific performance are mutually exclusive. It's either the one or the other, but never both at the same time. You cannot do and not do at the same time. With regard to damages, however, damages is always available. So whether the court ordered specific performance or whether the court ordered cancellation, in addition to that, the innocent party can claim damages, monetary compensation. So that you can get, whether it was specific performance or cancellation, you will always potentially have a claim to damages. We'll talk about that in a little bit more detail shortly. Just a bit more detail about these two. Specific performance is the remedy of choice. Our courts like contracts. If I remind you what we did on Monday, when we got to, when we were doing the restraint of trade, quick reminder, with the restraint of trade was regarded valid because our courts emphasized the concept that contracts must be upheld. The same thinking also happens here, namely that if it is at all possible or feasible, the court will grant specific performance rather than cancellation. Courts believe that if parties entered into a contract, they actually did so because they want to achieve a certain result. If there's cancellation, they won't achieve that result. So if it is possible, if specific performance would be possible, that it would be the way to go. Obviously, if the type of breach is, what happened there? If your type of breach was prevention of performance, sorry, I just pressed something that I shouldn't have done. There will never be an order for specific performance. Why not? Logic once again. If the type of breach is prevention of performance, why will the court then not give the remedy of specific performance? Mr. Menard, take a chance on this one. It relates to your previous answer that you gave. And your logic seems to be on point tonight.
Okay, I believe so. The type of breach is prevention of performance. If you've been prevented from performing according to the contract, they can't. The court can't issue specific performance to take place because you have been prevented from performing.
Absolutely, absolutely. Once again, not a difficult legal concept, just absolute logic. Prevention of performance. The data does something that makes performance impossible. If performance is impossible, it cannot be done. And no court will then give you an order saying, go and do something that can no longer be done. But otherwise, in most instances, the court will prefer specific performance. Cancellation. Courts are not inclined to order cancellation. Parties can provide for that in their contract. We saw on Monday, we did the cancellation clause. I didn't type it out here, but there I just mentioned it. Cancellation clause is specifically a clause giving the innocent party the right to cancel the contract. So if there's a cancellation clause, if performance no longer possible, or in some instances, if performance will cause undue hardship, or in instances where performance is of a personal nature. What do I mean by that? That relates to things like contracts of employment. If I had a contract with Severinus that he will work for me, and there was some fallout, some breakdown of the employment relationship, I breached the contract, making it impossible or not feasible for him to continue working for me. The court won't give an order that I must reinstate him. The court will then rather, because of the personal nature of the employment agreement, would rather cancel the contract and compensate him by way of an order for an amount, monetary compensation damages. So in those three instances, courts will be prepared to order cancellation, but in most instances, the court will opt for specific performance. Now, a claim for damages, I said that you can get specific performance or cancellation plus damages. But that doesn't mean you're always going to get a bag of money. Only get damages you need to prove that you suffer damages. How are damages calculated? Damages is not a get rich quick scheme. It's not the court randomly giving you 6 bags of money. Purpose of damages is to put the innocent party if there was no breach. So not to make you rich, but just to equalize things, to put you in the position that you would have been if there had not been any breach of contract. In order to claim damages, you need to prove the following. You need to prove, firstly, that there was breach of contract. Then you need to prove the damages, the amount of the loss. So it can't be just any random amount. You have to prove how much money you lost. Then you need to prove factual causation. That the breach caused, that the two are directly correctly, that the breach caused the loss. That it could have been foreseeable. So when the party breached the contract, they could have or should have realized, should have foreseen that the innocent party will suffer loss or lose money as a result of this. And then mitigation of damages. Mitigation, the innocent party has the duty to restrict the amount of damage. So for example, if the contract was to build a security wall and the wall collapsed and now there's a security risk and Tutsis come and break into the house, the innocent party should have tried to mitigate their damages. They should have tried to erect a fence. They should have hired a security guard. They can, of course, claim whatever they paid for the security guard, but you cannot just sit back and say, okay, you've breached the contract, I'm going to make money out of you. You have to try to reduce as far as possible the amount claimed. Remember those 5 things? That is a very useful question that I often use if I'm short 5 marks in a test or an exam. I will ask you to list the elements or the requirements that have to be proved in order to claim damages. So make sure that you have studied them. Any questions? No questions. Let's go on to Unit 7. We've learned so far the requirements that are necessary for a contract to come into existence. Then we looked briefly at the contents of contracts, and then we've now just looked at what happens if something goes wrong. But contracts must also come to an end at some stage, namely termination of contracts. How do contracts come to an end? The most common manner in which contracts come to an end is by way of performance. That's logical and self-explanatory. If everybody has done what they're supposed to do, Evelina has paid for the cell phone and Daniel has delivered the cell phone in the condition it was supposed to be, then their contract terminates. They've achieved what they set out to achieve. So that is the most common manner in which contracts come to an end. Alternatively, another manner is effluxion of time. I hate that word, effluxion. It's just a nasty word. Passing of time. That is when the contract was for a specific period of time. So Marilyn rented a room in my house for 6 months. After 6 months, our contract will terminate. If it was for a period of time, once the time has passed, passing of time, you can also say expiry of time. I will accept that as well because effluxion is just a horrible word. Then, in addition to those 2 manners, contracts can also come to an end by way of agreement. We started off by learning that a contract is an agreement between parties. Now, if parties could agree to enter into a contract, they similarly have the right to agree to end their contract. That makes perfect sense, does it not? Number of ways recognized where contracts can come to an end by way of agreement. The first one is release. Also known as waiver. That is where one contracting party literally agrees with the other contracting party that they abandon their rights, performance is no longer required. So Evelina bought the cell phone from Daniel. She was going to pay $200 a month off for 5 months. After 3 months, he says to her, it's okay, you don't have to pay the rest. He has waived his rights. He has released her from the contract. Another way in which parties can agree to terminate a contract is by way of novation. Let's carry on with Evelina and Daniel. Next class, I'll use some different names, but we're busy with Evelina and Daniel this time around. So Evelina bought Daniel's cell phone and agreed she will pay him $1,000 at the end of the month. The end of the month, she approaches him and says, I'm running into some problems. And he says, okay, you don't have to pay the full amount now. You can pay me spread over 3 months. So in fact, they enter into a new contract. The initial contract for payment, lump sum payment, comes to an end. Novation, a new contract she can pay in installments. Or there is compromise. Compromise is similar to novation. Compromise, also known as settlement. Compromise is similar to novation in the sense that there is a new agreement, but compromise will always follow a dispute. So that's where Evelina has agreed to buy Daniel's cell phone. When she pays him $500, and he says, no, our agreement wasn't for 500, our agreement was for 1,000. And then they talk about it and they compromise, they agree on 750. So it's also a type of novation. There's a new contract, but it has followed an argument, a dispute. In some instances also, a contract can terminate due to operation of law. There can be certain legal factors which will lead to the end of the contract. First one is set off. Set off can only take place with regard to contracts that involve the payment of money between the same parties. Let's type that out for you. So this is actually quite self-explanatory. If Evelina has bought Daniel's cell phone for $1,000. But some time ago, Daniel bought something for Evelina for $500 that he still needs to pay. So now Daniel owes Evelina $500 and Evelina owes Daniel $1,000. What is going to happen here? Set off. He isn't going to pay her 500 and then she pays him 1,000. No, you're going to subtract the smaller amount from the larger amount. She only needs to pay him 500. This one is a little bit more complicated. Merger. Often my students struggle a little bit to understand this one. We've learned about debtors and creditors, that for every obligation, there's a debtor and a creditor. But if circumstances change, the same person cannot be debtor and creditor. You cannot owe yourself money. Let's say Marilyn rents a room in my house. 6 months later, she buys the house. So while she's my tenant, Marilyn rents a room in my house. She needs to pay me rent. I'm the landlord. Now she buys the house, which means she becomes the landlord. She cannot rent a room from herself, which means our lease agreement will terminate as a result of merger. When circumstances change, things happen, which has the effect that the same person becomes both debtor and creditor. This is one that you might not know about. Extinctive prescription. In terms of the Prescription Act 68 of 1969, you don't need to remember that. Dates don't last forever. I've given you only one example. There are different dates or time periods. The only one I've mentioned in the notes, contractual dates, so dates that arise from a contract will prescribe after 3 years. They will prescribe. What does that mean? It falls away. So if I've owed you money and for 3 years I haven't paid and you have made no effort to collect the money from me, if you come to me after 3 years and say you must pay me now, I'm going to say to you, no, our date has prescribed. You waited too long. And then the last one is supervening impossibility of performance. So if something happens after the contract was entered into, which makes something that is not in control of the parties, makes performance objectively. So not if you lose the money that you have to pay, but objectively impossible. Then the contract will come to an end, the contract will terminate. Be careful here. This is something I'm going to ask you also in the test. Don't confuse these two. Objective impossibility of performance. That is at the time of contracting. Possibility of performance is one of the requirements for a valid contract. Objective impossibility of performance at the time of contracting. Performance is actually impossible. One of the requirements for a valid contract is not met. The contract is void. Supervening impossibility of performance. Remember, I stressed at the beginning of today's class, we have a valid contract. It's not suddenly going to go void. Supervening, so that is after contracting. The contract will terminate. Okay, that's it. Done with Unit 7. Do you have any questions? We did a lot of work today. We went at quite a speed, but it's not very complicated work. It's basically studying memory items. Any questions? No questions. Lovely. Have a lovely evening. It's still nice and early. It's nice and cool out. We had some lovely rain today. If you are driving anywhere, please be careful. Wet roads are absolutely treacherous. Don't speed. Take your time. Brezhnev tells me he will have some questions for me on Monday. So that shows me that Brezhnev intends spending some hours over the weekend going through the notes carefully. That's what all of you should do. Good for you, Brezhnev. If you come across anything in the notes that you don't understand, please do ask. You don't even have to wait till Monday, Brezhnev. If you come across something in the course of the weekend that you don't understand, feel free to ask me on the group, and I will also answer on the group, and then everybody can share. Or alternatively, do ask me on Monday. Okay, wonderful. Great stuff. Have a lovely evening.
Same.
Bye.
Thank you. Good evening.